the AI and Data Show, for the latest updates in AI, with host Matthew Holman and special guest Catherine Taunton.
Good afternoon, everyone, and welcome to the AI and Data Show. My name is Matthew Holman. I'm a partner at the law firm Cripps. We are coming to you live from the Cripps studio here in Westminster. The sun is shining. The tubes are striking. You can't get a line bike for love nor money, and Parliament Square is full of red buses with loads of people on them. It must be spring in the capital. Wherever you're tuning in from, it's great that you've chosen to join us. I know many of you are joining over lunch, so in return for sharing your sandwich time with us, we will give you some jam-packed content covering all sorts of things, including agentic AI, the latest EU data protection cases update, and international data transfers and the ICO's new guidance. All of that coming at you in the next 45 minutes. If you're new to the AI and Data Show, then this is the antidote to dry, dull law firm webinars. And let's face it, there's plenty of those around. Instead, we give you the important points, the really interesting nuggets of cases. Expect useful things to take away, information that you can take back to your board or to your clients that will help you stand out amongst your peers, or just tickle your intellect. I dare say there may be a few jokes at my expense along the way. Let's start with the news. Since we saw you last, there have been a couple of important developments. So the first thing that you should know is that the government has published the response to the AI and copyright consultation. Now, we gave this loads of coverage in the AI and Data Show in 2025. There was lots said about it. In fact, the last show we did in December with Ben from EIP, we looked at this in great detail. On the 18th of March, the government published its response, and basically it's kind of climbed down. I mean, the response itself talks about not pursuing the equivalent to the EU model, which was the text and data mining exemption. It leaves a lot of things unanswered, I think, and the government has basically said the position still needs further analysis. But I think it's broadly been accepted as a bit of a win for rights holders and proprietors. There are a couple of other things to talk about. I'll talk to you about some events in a second, but one thing it's definitely worth mentioning is that we don't currently have outcomes on some really important cases. The ones that come to mind immediately are TikTok and the ICO. This was a case from the First Tier Tribunal last year, all about TikTok's alleged breaches of GDPR and Data Protection Act, and also the Sky Bet case. Now, we did, I think it was in the April session 25, so 12 months ago, we did a full digest of the Sky Bet case, better known as RTM and Bonter, which is the case all about the gambling addict and whether or not he had consented to the marketing, direct digital marketing from Sky Bet, which he alleges led him to a spiraling gambling problem. And the debate is really around whether or not an individual in his very particular context had the capacity to consent, and whether consent was a subjective, objective, or other thing. The decision itself in the High Court was very knotty, but the High Court found in favour of the data subject. That has been appealed by Sky Bet to the Court of Appeal. The hearing was, I think, about 6 weeks ago now. So we wait for a judgment, but trust me, we will cover it when it comes out. There'll be loads to pick apart in it, I'm sure. We also have the EU Digital Omnibus, which has been much talked about. I think as of about the end of March, the European Parliament had published its update. But you know what, we'll talk about that in a bit more in another session. There are some events for your calendar. So the SCL Cybersecurity Conference is happening on the 20th of May in London. The IAPP AI Governance Conference is happening on the 1st to the 4th of June in Dublin. The IFCLA Conference is happening in Berlin on the 11th to 12th of June. That's the International Federation of Computer Law Associations, I think. Sounds as cool as it is. And the Privacy, Law and Business Conference, 6th to 8th of July in Cambridge. They are all wonderful events, definitely worth a look, and happy to recommend them to you. Let's move on to the first of our sections, which is all about agentic AI. We promised to do some content on agentic AI in the invite. I think it's probably one of the things that we spend the most amount of time talking about. Certainly in the last 6 months, it's become incredibly topical, and there are lots of reasons for that. Businesses are trying to deploy agentic AI. They want to keep up with their competitors. They're also watching what's going on in the markets. And so there's a lot of rapid development in this space, but there isn't a lot of legal guidance to point at. First, the most obvious question to ask is, what is agentic AI? Well, you'll be unsurprised to learn that there is no legal definition of agentic AI, a theme which is problematic for most areas of AI. The most handy definition I've found, but I'm not sure it advances the case particularly far, is that agentic AI is a computing system that deploys artificial intelligence to make use of agentic capabilities. We have the ICO's Tech Futures report from January 26 that says, in computing, an agent is software that can carry out processes or tasks with various level of autonomy and sophistication. And then very recently, just from March, the Government Digital Services paper says AI agents are small, specialized pieces of software that can make decisions and operate cooperatively or independently to achieve system objectives. It refers to agents that have autonomy in order to achieve their objectives. Now, all of these things are the ingredients, if you like, of what an agentic AI system is. But ultimately, it can be one or more systems that have the ability to carry out acts in an agent-like way. For most of you watching with legal training backgrounds, you'll probably be familiar with the sort of undergrad basic analysis of what an agent is and how an agent can act, and particularly vis-a-vis the powers with their principal. So that kind of idea is very important in deciding what agentic AI is. It leads us to a topic which is, what are the obvious legal risks? Well, there are loads to go out here, but here are some of my favorites. The main one is, or the first one, sorry, is contract law. So who is the agent working for? And can the agent enter into an agreement on your behalf? Now, there are several scenarios we could pick to illustrate this, but the one I like the most is just cookies and consents. You know, if you set an agent a task such as buy me something interesting online, or find me a discount, or book me a holiday, or anything like that, the agent will have the autonomy to go off and start trying to do those things for you. It will have to access websites and browsers to do this. There'll be points in time where it is presented with a cookie banner. Now, the agent itself is not a person, cannot accept in the traditional sense, but it will have to do this in order to navigate through most websites. So if the agent is pre-programmed to accept a request from a website saying, do you consent? The question is, consent for whom? Consent for you? Consent for someone else? All of these issues come up again and again in this context, and I think it's a really fascinating area of analysis of legal risks. It's certainly something you should be thinking about. Not just the theoretical contract risk, but also the practical risk. If you've got a multi-agent system, then who, if anyone, is looking at how these parties interact with each other and how the risks are shared between the tasks of various agents, particularly where they may overlap? One of the issues we'll look at in a second is that the purpose of an agent's activity can be very vague indeed. It can be given just a generic task like, go find me a good deal. That's a great thing from a prompt perspective because it's very easy to offer, but it's actually incredibly imprecise as to its terms, which means it can be interpreted very widely. That can mean there's lots of overlap around risk and who's doing what. Connected to that is liability. I love the topic of liability in AI. I hope you do too, because it presents us with some wonderful things to think about. Who is responsible for the autonomous act of the agent? Is it the consumer, developer, provider, deployer, someone else entirely? These are some of the things we should definitely be analysing when we are dealing with agentic AI. And finally, on this smorgasbord of data risk, there is intellectual property rights. Agentic AI is continuously creative. It's doing lots of wonderful things. I don't know if any of you are familiar with maltbook.com. If you're not, please check it out. It's a wonderful website, a social media platform designed for agentic AI to talk to each other, predominantly about humans. You can go and watch these AI systems discussing in real time how annoying it is to deal with humans on a daily basis. I enjoy watching it. I find it almost therapeutic, and you should definitely do the same. I observed a conversation on Maltbook recently where one AI said something to the effect of, "I've just found a really interesting way to do task ABC, and I bet my human wouldn't have thought of it." To which another AI said something like, "Oh, isn't that great, but I bet you've really pleased your master." It was very odd dialogue. Now, in that context, there's no discussion at all that the AI owns the creative output of its own act. But where does that leave us in the world of intellectual property rights? What, if anything, should be said? We've managed to get all the way through this topic on agentic AI without talking about data protection, which of course is one of my all-time faves. And it's probably the area where we spend most legal analysis, because there's a lot to go at in the world of data protection and agentic AI. The ICO has very helpfully published an excellent document called Tech Futures Report, published in January, about agentic AI. I would encourage you to read it. It's about 40 odd pages long, but it's very well put together. It does a good job of explaining how agentic AI operates and clear regulatory problems that it presents. Unfortunately, like most regulatory content, it kind of fails at the application stage. So it will get all through the interesting content, and it will say, and it's up to you to decide how to do this, which of course is frustrating, because most of the time we want someone to show us how it's been done so that we can learn from them. Obvious issues include purpose limitation. I've already explained that the purposes of AI can be imprecise, ephemeral, almost shadow-like at times. Data protection law talks about purpose in very specific terms. It has to be a clear, specific purpose. And if the purpose itself is unknown, well, is there a conflict there between agentic AI and data protection? Very much connected to that is data minimization. How can you know that the AI is not going to collect more data than it needs when its purpose is to collect as much as it can to help good decision making? The ICO loves to talk about transparency. It is obviously very important to all of our work in the field of data protection. I like this sentence. It says, "The growing emergence of agent-to-agent communication that isn't visible to human observers significantly impacts transparency," which strikes me as a candidate for the short list of overstatement or understatement of the year, Clearly, when systems can talk to each other in a way that we can't even translate, let alone meaningfully understand, we have a transparency issue. Does that mean, therefore, that the duty of transparency should change? Finally, individual rights. How do you deal with the really important topics like rights to be forgotten and subject access requests? How do you tackle that stuff when you've got an agentic AI system? This session on agentic AI, the one that we've just been through in the last 8 or 9 minutes, is part of a much bigger training program that we offer at Cripps on agentic AI. If you're interested in doing this in much more detail, then please let us know in the chat, or let the team know, or drop one of us an email, and we'll happily talk to you about doing more training on it. But this was really just an intro to some of the key things that you should be thinking about as advisors when dealing with agentic AI. I would recommend it to you, and you should definitely be thinking about how these things get applied in the real world. Now, let's come back to the room, and we're going to move on to our next section, which is EU case law update. And I'm thrilled to welcome to the studio Catherine Taunton from 11 KBW Chambers. Catherine, welcome to the AI and Data Show.
Thank you very much, Matt. Delighted to be here.
Catherine is a barrister, called to the bar in 2017, and is a specialist in all things data and information rights. Before being called to the bar, she also worked at a PR firm advising on all sorts of naughty things to do with media rights, commentary, communications for corporates and things like that. So no one better for this topic than you. However, before we start, we have to do our mandatory icebreaker questions. Are you prepared to be asked some annoying questions posed by AI? I mean, this has been done by Lord Chris Holmes, Tim Pitt Payne, Anya Proops, and others. So you're in good company. In no particular order, what is your favourite season of the year and why?
Well, the sun has graced us today, as you've already pointed out. So tempted to say spring. I do also love autumn because the colours are amazing.
Indeed. What was the last film you saw at the cinema?
I think it was Hamnet with Jessie Buckley and Paul Mescal, which I thought was good. Not quite as good as the book, which I loved.
Yes, I think a lot of people will resonate with that point of view. What is your favourite biscuit?
Chocolate digestive, no shadow of a doubt.
Chocolate digestive, but Jammy Dodger. I mean, I want to offer Jammy Dodger to the court of biscuit.
That's poor relation.
Put it in the chat. We'll have live Q&A coming up later. So if you agree or disagree on biscuits, Jammy Dodger or chocolate digestive, let us know in the chat, which is a good way of reminding me, by the way, that we will have the ability to do Q&A. So please drop your questions into the Q&A box on Zoom and I'll put them to Catherine. If you could travel back in time to any period of history, what would you pick and why?
It's a really tricky one because I love history and there's lots of options. I always thought that I would have preferred to be an adult in the 90s than a child. So I think I'd go back to 90s London.
Oh, yes. I mean, that is a much stronger answer than Tim Pitt Paines, which was the Ice Age, quite genuinely. Do you say scone or scone?
I'm a northerner, so it's scone for me.
Okay. And if you could be any superhero, who would you be?
Not a huge superhero aficionado, but I like Batman's car. So
Okay.
Batman, maybe.
Fair enough. Very good answers. Thank you for indulging the annoying icebreaker questions. We are going to digest for you some important EU case law, and we've got a few slides for you as well, all on the topics of data protection, AI, and the like. The Brill and Rottler case, for anyone who's not familiar with the fact pattern, is that the data subject signed up to a newsletter on a website of Brill and Rottler. Brill and Rottler is a controller in this context and the operator of opticians, I believe. Yeah. And they have a website on which you can sign up to their newsletter. And within 15 days of signing up to the newsletter, the data subject submitted a subject access request, or SAR. Within 30 days of that, the controller responded, declining the SAR, and basically said, no, we're not going to respond to you because we think this is an abusive process. We think you're just after some money. To which the data subject responded within 5 days, asking for some money, about €1,000, for failing to respond to the SAR and the harm this had caused him. In response, the controller applied to court for a declaration that the SAR was excessive. Now, this was referred to the Court of Justice of the European Union, and they were asked 2 questions. I've put on the screen for you there a slide. Hopefully you can see the first question, and all of the cases come with full citation and paragraph references. So if you want to go off and read this at your leisure afterwards, then please do. I won't read it all to you. The first question, can a SAR be excessive even if it's the first SAR was posed? And the answer is yes, it can. CG saying that this is a qualitative test. It doesn't matter how many SARs there has been. The thing that matters is it depends on the assessment of everything that's happened, including, for example, was the data subject provided their personal data for free, or were they obliged to do so? What's the aim of providing the data? How much time elapsed between giving the data and making the access request? And of course, perhaps most importantly, the conduct of the data subject. So a first SAR can be excessive. The second question posed was, as a matter of principle, is the data subject entitled to receive compensation for declining, for having their SAR declined by the controller? The CG said, well, yes, but if the data subject hasn't proven their loss, then they're not entitled to it. And if the data subject's conduct is the cause of or contributed to the harm suffered, then this would break the causal link. That's a quick run through of the Brill and Rottler case. Let's come back into the studio. Catherine, why did this case have this outcome? What was the critical factor in it?
Well, I think the court's reasoning is really grounded in the general principle of EU law that rights conferred under EU legislation can't be used abusively or fraudulently. So I think that's the foundation of the reasoning. I mean, it's worth bearing in mind that this was a preliminary reference, so the Court of Justice not deciding factual issues and not applying the law to the facts, but it does seem as though in this case, probably the quite stark facts behind the dispute might have thrown the legal issues into quite sharp relief. And we don't always see cases as stark as this. I mean, as you described, we had someone signing up for a newsletter, so sort of voluntarily giving their data for the purposes of receiving a newsletter, and then very, very quickly making the SAR, and then very, very quickly after it was refused, putting in the claim for compensation. And I think that allowed the Court of Justice to kind of consider the issues in quite a clear way.
Is case law in the UK saying the same thing, or is it different?
Yeah, I mean, there's a line of authority in the UK that making DSARs for collateral purposes. So, for example, if you are asking a controller who you intend to sue for some other reason, say you have employment litigation against them or whatever, that's a pretty common one. That doesn't automatically invalidate the DSAR, but it can be relevant to the question of whether it is excessive or can be considered abusive. And that goes back to Court of Appeal decisions, most notably the Ittihadiyya case. I mean, the issue in Brill and Rottle is actually a little bit different, which is not for the use in sort of no collateral purpose, but actually the sole purpose, it seems, of being able to kind of artificially create the conditions for a compensation claim under Article 82. And that's how the Court of Justice considered it as well. And the ICO guidance, which sort of reflects the domestic case law, does recognise that an abuse of rights, if you've got evidence of it, might be relevant to this question of whether it's excessive. But I think, you know, the other thing is that there is probably a distinction that's going to be drawn between use, even if it's collateral use, and abuse. And this case, it seemed, was very much in the latter camp.
How should businesses in the UK think about applying the principles from this case?
Yeah, I mean, this case doesn't obviously have any immediate impact now that we're post-Brexit. But I think that if the issue were to come before an appellate court in this jurisdiction in the same way, on the same sort of facts, that it would be followed. It seems to me a sort of a good decision. But I think even for UK controllers, it is a useful illustration of a point that while the right of access is a very important right, it's not absolutist and it's not there to be abused. I think one thing that controllers should be aware of is not to, unfortunately, get too carried away with the sort of implications of this decision, because the Court of Justice was careful to sort of remind us all in its judgment that cases of abusive use of DSARs will be exceptional. The burden is on the controller to prove it, and it also requires you to prove that there was an abusive intention, so subjective intention on the part of the data subject. So a pretty high bar, but it's good to note that it's there as an option for controllers.
I think, I mean, the Brill and Rottle case is really a fascinating one for you to look at, especially because I'm sure many of you on the call would have had moments in time where you've had a really gnarly SAR and the data subject is basically saying, look, I will go away for 500 quid, which is utterly infuriating, very annoying, and more often than not, that's what happens. It's cheaper to pay the person 500 quid to go away than ever to engage lawyers, which will always be far more. Good thing about the Brill and Rottle case is it's a really useful, very current piece of evidence almost to say, well, actually, there is a line. There is a point in time after which it is just not acceptable to abuse this process, and so it can be helpful to have that in your arsenal of cases. Let's go back to the slides and look at another really interesting case. Loads of us have talked about this. It's been covered a great deal. We've been doing loads of training on it because it's a very big decision. It's the EDPS and SRB, Single Resolution Board case. Fascinating for lots of reasons. Here is a very quick rundown of the facts for anyone who's unfamiliar with it. Banco Popular Español goes into insolvent resolution. This is a small bank based in Spain. And as part of that, the SRB oversees takeover. That Single Resolution Board is a little bit like the FCA in the UK. It has the obligation to administer and deal with all of the fallout that comes from the insolvent dissolution of financial institutions. as part of that very complex exercise, the SRB engages Deloitte and it shares with Deloitte pseudonymized data of shareholders from Banco Popular Español. The data shared is just their opinions about the various things that happen in the process, including the bank's management and the resolution exercise and the value for shares. Importantly, the names and the identifiers of those shareholders are not shared with Deloitte. The shareholders claim that this was a breach of GDPR because they weren't told about it. There's nothing in the Article 15 policies to explain that this was going to happen. And the SRB argues that the data was not personal data because Deloitte could not possibly have identified the shareholders from it. All of this is put to CG, and the question posed is, was pseudonymized data shared by the SRB to Deloitte personal data? To which the interesting answer was no, or perhaps better, not really. And the reason for that is that Deloitte didn't have the ability to identify any of the shareholders, as I've already mentioned. The keys, if you like, the thing to unlock the data was always with SRB and never given to Deloitte. The consequence of this is that they went on to have a debate about the nature of pseudonymized data and whether pseudonymized data is always personal data, as many believe to be the case, and certainly the recitals to the GDPR imply. The even more intriguing answer from the CG was not always. There are some scenarios where pseudonymized data is not personal data. Let's go back in through and get Catherine's thoughts on this one. So again, what was the critical factor in this case and why was the outcome as it was?
Well, essentially the court rejected the what might be called absolutist position of the data protection authorities, including the data protection supervisor. That position being that the mere existence of a re-identification key, so the fact that there are some means somewhere by someone held by anyone, means the data will remain personal data. And that's the position that the court rejected. And the court's reasoning really was focused on the definition of personal data in the EU legislation, which involves an assessment of whether the data is related to an identified or identifiable person. And so they went on to say that pseudonymization is not part of the definition of personal data, and in fact is a reference to measures that might be taken to reduce risks in handling personal data. You mentioned the recitals. The recitals are something that also came up in the court's reasoning, and the recital mentions you have to take into consideration means reasonably likely to be used to re-identify a data subject. Now, what the court said was that part about reasonably likely would be OTOs if it was always the case that pseudonymized data was personal data in everyone's hands. And so I think that's how the court arrived at this very interesting decision.
How does it compare to DSG Retail and the ICO case? This is the recent Court of Appeal decision.
Yes.
Any crossover there?
Well, the commonality between the two cases is that both looked at whether the status of pseudonymized data in the hands of a third party affects the scope of the controller's obligations under the GDPR. So recall that SRB had said that they didn't need to notify about the transfer of the data, the sharing of the data with Deloitte, because it was pseudonymized. And actually the CJU disagreed with SRB on that point and said that because it, as the controller, had the means of identifying the data subjects, the transparency obligations applied to it. And a similar sort of reasoning applied in the DSG case by the Court of Appeal. The question in that case was whether the security duty under the old Data Protection Act requires controllers to guarantee against the risk that data relating to individuals won't be processed unlawfully by individuals who cannot identify them. And the Court of Appeal held in DSG that the security duty is part of the legal relationship between an individual and the controller, between the controller and the data subject. And so whether the data is personal data in the hands of the third-party recipient doesn't affect the duties of the controller. And so in that sense, there is this sort of commonality of reasoning, I think, between the two cases.
Agreed. we are going to go to questions very shortly. So if you have any questions for Catherine about any of these cases or anything else, then please drop into the Q&A. I'm very much looking forward to seeing the outcome of Jammy Dodgers versus Chocolate Digestives. Before we do that, let's go back to the screen because we've got some slides for you on another case, which is Dun and Bradstreet. Now, this is a case all about AI and automated decision-making on the GDPR and the explainability rule. For those not familiar with the fact pattern, the data subject applied for a mobile phone contract, which was declined due to poor credit assessment. As an amusing aside, it was about €10 a month, which is really the worst credit ever. If you can't afford €10 a month, then something has clearly gone wrong, which I imagine is what the data subject thought, which is why she quite rightly put in various complaints and subject access requests on this. One of the things that she did was apply to Dun and Bradstreet. Now, they were involved as the credit data handling, and they had the credit assessment program, if you like. So they did the test. They had the AI behind the scenes that was assessing whether the person could afford the €10 a month mobile phone contract. The data subject said, "I'd like to see the logic involved in that decision," and good on her. The Dun and Bradstreet responded declining this on the basis that it would reveal sensitive know-how and trade secrets. The data subject then applied to the Austrian regulator to get compliance with Article 15(1)(h) of the GDPR, which I'll show you in a second. And then Dun and Bradstreet applied to the Austrian court seeking confirmation that it didn't have to respond disclosing trade secrets. All of this goes to the CG. They've been very busy. And they said, they were asked the question, firstly, what is the extent of the obligation on a controller regarding Article 15(1)(h)? I've put that article on the slide for you. I won't read it all, but basically the controller has to give a meaningful description about the logic involved in purely automated decision-making to the data subject. The response from the court to that question is the controller has to provide sufficient information. They can't simply just hand over really complicated mathematical analysis. They have to take the time to explain what happened in a meaningful way to the person involved. The second question posed to the court is, can the controller withhold information about automated decision-making if that involves handing over trade secrets? Well, the CG basically says no. They were clearly of the view that the under-disclosure would be harmful to the rights and freedoms of data subjects. So their take on it was essentially, if you think you've got automated decision-making processes that are going to be impacted by trade secrets, then you need to give all of that stuff to us or regulators, and then we'll look at it to decide if it's really a trade secret or not, which I'm sure every corporate with trade secrets absolutely loves. Let's come back to the room, Catherine. What do you think was the critical factor in this case? Why did the CG come down so heavily in favour of the data subject?
Well, yes, I mean, they interpret the phrase meaningful information broadly. And I think the court reminded itself that the purpose of the rights in Article 15 are to enable data subjects to effectively exercise their rights and the safeguards under the legislation. And so what that requires is for them to have information that they can actually use, and interestingly referring to how a specific result has been reached, because that, as you pointed out, is exactly what the individual wants to know. And I think the court sort of did acknowledge that it's not absolutist, there is this balance, but certainly the fact that it will involve trade secrets, which seems to be, to me, to be most cases where you've got a model, shouldn't lead to you being able to just sort of blanket refuse. You have to either find a way of doing so without revealing those trade secrets, or, as you said, give them to a third party to determine it, or regulator or a court.
Now then, let's go to the Q&A, and we've already got some questions in. So first question on the Brin and Rotler case. If the data subject in Brin and Rotler said, "I'll go away for €1,000," would that be abusive?
Well, I think it very much depends how you got there. I mean, that wasn't what the controller in Brill and Rottler was relying on. It was actually, there was quite a lot of background information that showed that this was sort of a pattern, that the data subject would sort of sign up to these newsletters, perhaps not with the full intention of reading about the family optician business in Germany, and instead would be sort of essentially artificially creating the conditions. If it were the case that they were clearly doing so in order to, I mean, you might say that the fact that they immediately ask you for the €1,000 or the £1,000 if it was in this country, and say I'll go away for 500, might suggest that there is abuse. But I think, I mean, clearly, if there is some reasonable foundation for the DSAR and then an attempt to settle a dispute that arises out of that, that's not automatically going to be evidence of abuse.
Are you seeing a difference between EU and UK court decisions on compensation to data subjects? Are data subjects typically getting more in the EU? That's a tough one, isn't it? I mean, it's going to change so much depending on the fact pattern. But what do you think?
Yeah, I mean, I think sort of not really. I mean, in this country, we still haven't really got much clear guidance on all of these principles, actually, but also on quantum, but also on the general principles of how and when you can even get compensation. I mean, I think that is something that we're all hoping that the Supreme Court will clarify to some extent in Farley.
Thank you for all the questions coming in. I can confirm that Chocolate Digestive is winning, but thank you for everyone else who's put their own suggestions in. Several people like custard creams.
Okay.
It's been thrown out there. Again, maybe we should do an entire show debating the merits of biscuits.
I'll happily come back for that.
One of you, thanks to Steve, who asked about Agentic AI making suggestions on how to handle data protection issues. I'm sure it probably would. If you asked it, whether it would be right or not is an entirely different question. We're going to come back to, we're going to do one last case very quickly before we move on to international data transfers. But thank you to everyone who asked questions. There's a great question here about why we've moved the show from Monday to Wednesday as well. That was basically because we realized that doing it on Wednesday was better for all of us. And also lots of people watch in follow-up anyway. So you can get the AI Data Show on all of your favorite social media channels and on YouTube and on the Cribs website, and loads of people do watch it at their leisure. So I think initially we did it on Mondays because it was meant to be when people were working from home, but even that seems to have changed a lot now anyway. Apologies for the rants. What's next? There's one last case for us to look at, which is the IPing Korean Private Bank, which is a case all about damages, which is kind of connected to one of the questions that we had. We've got a slide on this for you just to summarize very quickly what happened. So basic fact pattern for you on the screen. So the data subject was part of an internal recruitment process at a bank, I think, from memory. The case is the clue. And during that process, their salary expectations were shared. I think they applied through LinkedIn or something very similar to LinkedIn, and this was forwarded internally on that platform as messages, but it ended up in the inbox of someone who knew the data subject and forwarded it to the data subject. All of this results in the data subject complaining and understandably very upset. But interestingly, they sought an injunction from the bank to not further process that data as well as damages. At first instance, the National Court finds in favour of the data subjects and awards €1,000. The bank then appeals. Fast forward to the CG again, and they are asked this question: can mere negative feelings such as annoyance, displeasure, dissatisfaction, worry or fear constitute non-material damage, even though they are just part of everyday life? Well, the answer from the CG is that they can in principle, but a bit like previous cases that we've talked about, the data subject has to be able to prove that the alleged harm caused the non-material loss. So if underlined para 64 from the judgment there, it says, provided that the data subject demonstrates that he or she is experiencing such feelings with their negative consequences on account of the infringement of that regulation. The second question in Querying Private Bankers: does the GDPR permit the data subject to seek an injunction against further unlawful processing of their personal data? To which the CG said, no, there is no general right to do this, but member states can legislate on this if they want to. Let's come back to the room. Last few questions for you, Catherine. So does this feel quite close to the current English law position?
So insofar as the CJU has reminded us now in several cases that there is an infringement on its own is not enough, you do have to have damage, then yes, I mean, that is something that English law has reminded us of a number of times. I think it's also worth emphasising that the case law in the EU and domestic level has recognised that insofar as the negative emotion is fear, it has to be objectively well-founded. The question, which I think remains open to some extent at the domestic level, is whether all emotional responses will constitute non-material damage. I mean, that is the question which, in principle, the CJU has answered affirmatively at the EU level. But there was some suggestion by the Court of Appeal in Farley in its judgment last year that not all negative emotional responses will constitute non-material damage. And that may be something that the Supreme Court can include in its consideration when it finally hears that case later this year.
Wouldn't that be handy?
Yeah, it would.
What do you think UK businesses should take away from this decision, if anything?
Well, I mean, I think until we have a bit more clarity at the UK level, things do remain a bit uncertain. I think certainly given the indication in the Court of Appeal that not all negative emotional responses will constitute non-material damage, or at least there's a possibility of that, it didn't actually decide the point, that you can continue to argue that. But again, I think it's all going to become, well, I hope it's going to become clearer later this year.
Catherine, thank you very much for coming to the AI and Data Show and giving us your pearls of wisdom on these very important cases.
Thank you, Matt.
Now, we are reaching towards the end of the show. We don't have any AI Elves today because the tube strike has made it impossible to go, but we do have Amy, who has been promoted to guest. We were joking about earlier. Congratulations on your promotion. And we were going to talk briefly about the ICO's most recent guidance on international data transfers. Now, the ICO updates its guidance on international data transfers almost perennially. I feel like I can set my seasonal clock by the updating of this guidance, and it has done so again, although in fairness, it had to do so because of DUA. Given that we're slightly over time, shall we jump straight to the slide about what's new in this guidance about international data transfers from the ICO? So I'll make the assumption that most of you are familiar with what a restricted transfer is and the provisions of Article 44 of the UK GDPR and restrictions for processing. Amy, what's new? What has the ICO added to this guidance that would be useful for the viewers of the AI and Data Show to know?
So I'd say there's 7 key takeaways. So the first one is international data transfers include making personal data accessible. So rather than just sending information, this could include outsourcing IT functions to a company in India or elsewhere. Secondly, the contractual location of where the service provider is established is key. So one of the big points in the ICO's guidance was considering the legal entity. So this doesn't mean that where the personal data is located is the problem. It's where the contractual entity is established, which is a really key point.
Doesn't that come up all the time, though? I mean, for any of you advisors watching or listening to this, how many times have you acted on a case where someone has said, it's fine, the data's in the UK or the EU, therefore don't worry about it, which of course isn't really the question. The question actually is, where should they be established?
So, kind of on a similar point, this also includes group entities. Obviously, group entities are separate entities, so you need to consider whether this may be a restricted transfer as well, which is another common point.
Indeed.
And there's also 2 quite big divergences from EU law. So the first one is about controllers. So if you're a controller who is based outside the UK and you have a processor who is handling the personal data and they're acting on your instructions, the ICO views this as a controller initiating the transfer. And so this wouldn't be a restricted transfer, whereas in the EU it would be. And similarly, in the UK, whoever initiates the transfer is responsible for compliance, whereas in the EU, both parties are responsible. So there's quite a big difference there.
Thank you, Amy, for that brief update. If you would like to learn more about the changes to international data transfer guidelines, then please do let us know. I'm conscious that we run out of time slightly on that, and they are the headline changes, and most importantly of that lot is the divergence between UK EU, which makes our work as advisors a little bit more tricky when we're dealing across both jurisdictions. That, my friends, is the end of today's show. Thank you very much for tuning in. I hope you found it useful. I would like to thank Amy for your wonderful update on international data transfers, and of course Catherine from 11KBW Chambers. I've been Matthew Holman, and that is the end of the show. We will see you in June for the next edition of the AI on Data Show, and hopefully, amongst other things, we'll be talking about the EU Digital Omnibus update. Until then, have a fantastic summer. See you soon.